can you tell us about the recent guidance and case law pertaining to authorised and unauthorised gifts of property so that professionals can understand how to advise their clients?
Yes, certainly. The recent guidance from the Office of the Public Guardian, entitled Giving Gifts, sets out the law that is applicable to both deputies and attorneys in relation to making a gift during their role as an attorney. And this states that they should only make a gift to a family member, an acquaintance, or a friend of the donor. And it should only be on a customary occasion or to a charity. In both these cases, it's essential that the gift is of a reasonable value only in relation to the donor's estate. What does the guidance mean by reasonable value? When deciding whether a gift is reasonable, you have to ask yourself, would the donor have made such a gift if they had the capacity to do so? Would it leave the donor with enough funds for their reasonable living expenses? If they have a will, would they have made a similar provision in the will? And lastly, what is the donor's life expectancy? You have to ensure that the donor retains sufficient funds for the remainder of their life. Ultimately, the gift must be well within what the donor can reasonably afford. The guidance also reminds practitioners that there are some gifts which are beyond the scope of the rules. And a senior judge in the Court of Protection reminded practitioners in the case of Public Guardian versus C in 2013 that certain transfers are not permitted. And these are, for example, loans to the attorney or the attorney's family, investments in the attorney's own business, sales or purchases below value, or transactions where there is a conflict of interest between the attorney's interests and those of the donor.